Hi, good afternoon to all of you who are with us from the East Coast and to all of you tuning in from elsewhere. We're glad that you've taken the time to join us. We have a great lineup. It is August 20th, so we are getting nearer to the end of summer. There's still plenty happening, even if some of you are thinking about when you'll squeeze in a few days of vacation, if you're fortunate enough to find them. We want to make sure that you're staying up to date regardless of the time of year. And so we have four attorneys here who will be presenting on topics we're confident are going to be of value to you. And we have a mix of offices represented here today. We have folks from our New York City and Westchester offices, as well as from our Rochester, Syracuse, and Albany offices. I'll introduce them more formally in a moment. Sophie, if you would advance to slide 3, please, I would appreciate it so I can walk through the agenda. Thank you. It doesn't look like the slides are moving forward on cue. So let me just take the moment now to walk through what the agenda will be. I'll make sure that all of you are familiar. We're going to start with Michael Collins. Michael is going to be presenting from our New York City office. And Michael, and I should say, Michael also sits in our Westchester office and spends more of his time there these days than in New York City. But has a long history out of our New York City office and someone I've enjoyed getting to know and I've had the chance to work with since I joined Bond. Michael is someone who also knows labor law quite well, and one of the areas that he tracks are updates around whistleblowers, and he's going to be sharing information on that with all of you momentarily, changes in the law that we think are relevant to all of you and your workplaces. After that, we're going to have Nick Jacobson with us. Nick is someone who sits both in Rochester and Syracuse. If you were tuning in last week, you might have heard Nick's name mentioned in the opening because Nick was going to present. We ended up running out of time, as sometimes happens, and Nick graciously has agreed to join us today. Nick is a member who also focuses on labor and employment and has an interest in making sure that you're up to date on some of the litigation that, in his view, is really topical and we think is going to matter to all of you and your businesses. After that, we're going to move to Mara Afzali. Mara and I are often, we have the opportunity to work together. While in New York City, don't sit in the same office, but I'm fortunate to work with Mara as a colleague, and she has been on the program a few times previously. Now she'll be here to talk about issues around notarization. There have been some changes in New York State, of course, with the pandemic. There were shifts, and some of them are getting solidified and getting tweaked, and we want to make sure all of you have the latest. And then finally, we will have Devin Karras on. Devin is a regular to the program. He's been on a number of times this summer. Devin sits in the New York City office. He is going to speak about ERISA. He focuses on employee benefits, and this is within his proverbial wheelhouse. We're glad to have him back to share what he thinks is new and topical and worth all of your time. So without further ado, let me turn to our first presenter, who is Michael Collins, and I'll make sure that Michael is properly introduced, although to those of you who know Michael, he is a longtime face familiar to many of you who has been on this program a number of times previously. He works out of our Westchester office, and as noted, he is someone who knows whistleblower standards quite well and wanted to take the time to update us all on what's going on. So Michael, thank you very much for being back on the program. It's always a pleasure to have you, and the floor is yours.
Thanks, Gabe. Good afternoon, folks. Hopefully everybody's having a nice day so far. I'm going to discuss, as Gabe mentioned, New York's whistleblower law, which has been significantly expanded and amended. That happened effective January 26th, 2022. In our experience, it takes some time after these statutes are broadly amended for some of the claims to start to percolate. And we've started to see that this year in particular, and we expect that trend to continue. So under the New York labor law, section 740, which is commonly called the whistleblower law, the prior law had been somewhat restrictive and was only applied to an employee who claimed a violation relating to a substantial and specific danger to public health or safety, or which constituted healthcare fraud. So it was very limited. In addition, the employee had to actually specify that a violation had occurred, meaning that an actual violation had occurred, and described how that violation impacted the defendant's activities, such as to endanger the health and safety of the public. So, for example, financial improprieties or claims of such were not covered under the prior law. Effective 2022, the entire statute was expanded. Under the new, broader statute, it prohibits any retaliatory actions against an employee who discloses or threatens to disclose any activity, policy, or practice of the employer that the employee reasonably believes violates any law, rule, or regulation. So that's a very big difference, right? It's expanding both the scope or nature of the type of complaint, and also changing the standard from an actual violation to a reasonable belief. So there were many whistleblower claims brought under the prior law that would get dismissed because they didn't fit into the more narrow box. That's no longer the case. Among the amendments are who can bring a whistleblower claim. So it always applied to an employee. It now also includes, under the amendments, former employees and independent contractors. So that's a big change. In addition, the disclosure can be made or threatened to be made to any supervisor, and supervisor is defined pretty broadly, or to a public body. So that's another change. So if an employee threatened to disclose, wrongdoing, any violation of any rule, regulation, or law to a public body, they would potentially or would be covered by the statute. So the employee no longer needs to specify the actual rule or law or regulation, but they must identify the activity, policy, or practice that they believe reasonably is being violated. Who can they report to? Any supervisor or public body. As I mentioned, a supervisor is anyone who controls the work performance of the affected employee. So even if the person doesn't have the actual managerial or supervisory title, if they effectively have control over an employee's work performance, they are a person to whom an alleged belief in violation can be reported. The statute covers retaliatory action, right? It's a retaliation statute, right? If a person says, I'm going to tattle, I'm going to blow the whistle on this practice, unless you do X, Y, Z, you can't retaliate against them. That's the whole protection that the statute offers. And what is retaliatory action? That's been sort of expanded or defined more specifically. Any adverse action taken by the employer or their agent to threaten, right? So even to threaten the employee is a violation, or potentially, or penalize the employee or discriminate against them in any manner. And as I just said, it applies not just to actions, but threats to current and future employment, right? So even potentially a job applicant might come within this very broad, encompassing statute. It also forbids any retaliatory action based on the employee's suspected citizenship or immigration status or that of their family. It also potentially applies to sullying the would-be whistleblower's reputation or employment prospects by disparaging them. What's required to demonstrate retaliatory action? The most simple definition is a causal relationship between the protected activity, the threat of whistleblowing, that is close in time, temporal proximity, and where there's any potential claim of a pretext for any action taken against the employee. Now I come to what I think is sort of the real sort of takeaways or things that you should be aware of in regard to the amended statute. It did several things that expanded the scope of the statute beyond what I've just described. It changed the statute of limitations from 1 year to 2 years. So now the employee has, or former employee or contractor or potential employee have up to 2 years after the alleged violation to report it and still come within the ambit of the statutory protection. It also provided the right to a jury trial, which didn't exist under the old law. Under the old law, an employee who was a would-be whistleblower was only entitled to a bench trial before a judge. Now they have a right to a jury trial. An employer is also required to post a notice. So similar to the notices that you're all probably familiar with, the easiest one is minimum wage and sort of the anti-discrimination laws. This is yet another right that employees need to be made aware of, and the posting can be in a conspicuous place. And for employees who are not in the office, remote employees, some form of reasonable notice to them, such as on, an intercompany website or something like that, is required. Beyond that, the damages that are available to the would-be whistleblower employee have also expanded. And in some cases, the employee would be entitled, where the violation, the whistleblower violation or retaliation, is deemed willful, malicious, or wanton, to punitive damages, which is a big departure from the prior statute. So I guess the main takeaways are the definition of what's encompassed has been substantially expanded. So now it's any law, rule, or regulation. The people to whom the statute applies has been expanded, and the potential damages that an employer can face based on a whistleblower claim have also been greatly expanded. So I think those are the big takeaways from this really significant change.
Michael, thank you so much for walking the audience through, and you provided an important heads up. I'm sure, though, that if anyone has questions, you're available and follow up. And so look out for those emails, Michael. And otherwise, please come on back to the program whenever you have more information to share. And
happy to do so, Gabe. Thanks for the opportunity.
Oh, absolutely, my pleasure. And let me now turn to our next speaker, who is Nick Jacobson, who sits primarily in Rochester, but also in Syracuse, and is someone who has been as well on this program a number of times, as I mentioned in my opening remarks. He was ready to speak last week, and we just ran out of time. We certainly don't want to do that this time around. We want to make sure that you hear from Nick about important updates in the litigation world that Nick thought were worth all of your time. So without further ado, Nick, let me turn the floor over to you. Thanks for coming back onto the program.
Thanks, Gabe. Next slide, please. Okay, so the first case that I wanted to talk about today is Sue v. Bevins and Sons. It's a very recent case from just a couple of months ago in May. and was decided in a district court in Vermont. For those of us here in New York, Vermont is within the Second Circuit as well, so this case could be instructive to cases in New York in federal court dealing with the same issue. So in Sue, an employee had a dispute with the owner of his employer over payment of overtime hours and threatened to make a complaint to the labor board. The owner then fired him, and the employee made a complaint just as he had threatened. The DOL conducted an investigation, and afterwards, the employer paid roughly $20,000 in back wages to employees, as well as an additional $25,000 to the employee who made the complaint for unlawful discharge. After the settlement, the DOL issued a press release covering the unpaid wages and the unlawful termination, and that press release was actually covered on the news. Next slide, please. After seeing the news story, the owner made a post on social media stating in part, "All we are going to say is please Google the disgruntled employee whom was fired and contributed to the story." And then he named him and said in parentheses, his word and character will be seen. After that, a commenter posted a screenshot of a Google search showing that the former employee had engaged in criminal activity. After the owner made that post, the DOL then brought an action in federal court on behalf of the former employee alleging retaliation, and the employer moved to dismiss the complaint under the First Amendment. Next slide, please. So on the employer's motion, the court held that employer statements designed to punish or otherwise unlawfully influence employees are generally not subject to First Amendment protection. I further noted that post-employment retaliation can be found under relatively narrow circumstances, including post-employment disparagement. In this case, the court found that the DOL had accordingly stated a claim because although the employer's post-employment disparagement of the former employee was true, it could still reasonably dissuade an employee from making or supporting a similar complaint to the Department of Labor in the future. So even though the post was not slanderous or libelous, it was still retaliatory because it would discourage employees from bringing complaints of unpaid wages forward. So it's still unlawful, even though it's true. Next slide, please. So our takeaways here are, like I just said, just because something is true and not actionable as libel or slander doesn't mean it's not actionable as retaliation. It's not a defense to a retaliation claim that what you said is true. Another important takeaway here is that the actions of employees can be imputed to the employer. So if you were dealing with a situation where there was a dispute between a former employee and a current employee, and the current employee posted something like that, depending on that employee's position, it could have ramifications for the employer as well. So something to consider if you're an employer and your employees are posting on social media about former employees or current employees who have made a complaint. That's certainly something that you're going to want to address to avoid a similar retaliation claim. And the final takeaway here is that employers have the potential to be sued for retaliation based on actions that occur even after employment is terminated. And those actions don't have to be as serious as the derogatory post in Sue. My favorite example of a post-employment retaliation claim that was sustained is in Orem v. SoulCycle. And in that case, the court held that the defendant's refusal to allow plaintiff and his counsel on SoulCycle premises could constitute an adverse retaliatory action. I think that's a bit of a stretch, that not letting the plaintiff or his attorney attend their their spinning classes at Soul Cycle could be actionable as retaliation, but a court has disagreed. So it's important to keep in mind that, just because the employment relationship has terminated, doesn't mean that you're out of the woods and that you don't have to worry about potential retaliation, because you can face a retaliation claim about things occurring after the employment relationship itself has ended. Next slide, please. So the second case I was wanting to talk to you about is Schoeneck v. JetBlue Airways. And you can see this isn't a super recent case. It's from 2017. But the reason that I wanted to include it in today's litigation update is it concerns an issue that I'm seeing pop up a lot more in cases over the past few years, and that's the administration of leave programs by a third-party administrator. So in Schoeneck, the employee was granted intermittent FMLA leave to care for her mother and son. The employer then hired a third-party administrator to administer its FMLA leave program, and the third-party administrator implemented a new call-in process that required employees not only to call their manager, but also to call the administrator to report their use of FMLA leave. The employee wasn't following that process, and they were disciplined for failing to do so. After they were disciplined, the employee correctly followed the procedure, but unfortunately, the third-party administrator made several mistakes in documenting her absences. Next slide, please. Ultimately, the employee was terminated for FMLA abuse, and she sued both her employer for FMLA violations and also the third-party administrator for tortious interference with business relations. The third-party administrator filed a motion to dismiss the claim, and it got out successfully. What that meant was that the employer was kind of left holding the bag in the case, and they settled for an undisclosed amount. Next slide, please. So what can we learn from the Schoeneck case? The most important lesson is that if the third-party administrator makes a mistake in administering a leave program, especially the FMLA, the employer can still be on the hook. Under the FMLA, employers are only protected from liquidated damages where they reasonably rely in good faith on decisions made by the third-party administrator. And so what that means is, first of all, if a court or a jury finds that the employer's reliance on the third-party administrator wasn't reasonable, the employer's on the hook still for everything, including liquidated damages. Even if the employer is found to have reasonably relied on the third-party administrator, if the third-party administrator made a mistake, the employer still is liable for any wages, salary, employments, or other compensation denied or lost, as well as any actual monetary losses sustained by the employee. So for instance, if a third-party administrator were to deny an employee FMLA leave to care for, like in this case, a son or a mother, then the employee could potentially recover the costs incurred to provide alternate care for their loved one. Additionally, if the third-party administrator made a mistake, the employer would still be on the hook for reasonable attorney's fees, expert witness fees, and other costs of the action, as well as the potential for equitable relief, such as employment, reinstatement, or promotion. So the big takeaway in this case, as more and more employers are turning to third-party administrators to administer leave programs, you want to be mindful of the fact that the employer is ultimately potentially still on the hook for any mistakes that the third-party administrator may make in administering a leave. So definitely think about indemnification and definitely think about ways to address any concerns that employees may raise that a third-party administrator has made a mistake. Thanks, Gabe.
Really appreciate it, Nick. I'm glad you were able to bring forward some cases from your practice that you see as bubbling up in the form of trends. And they're both, distinct, but I think in many respects, they're the kind of thing that our audience benefits from learning about. You're looking at the information coming across the transom and making sure that, by extension, the audience gets to glean the insight that we have. So really appreciate it. And we look forward to having you back on, whether for a litigation update or another topic of your choosing. With that, let me turn to our next speaker for the afternoon, who's going to be Mara Afzali. Mara is based in our Albany office, and Mara is focused on litigation and in the course of her work, has gotten to know the notary standards quite well and is here to tell us what's new, as I mentioned in my opening remarks, what is indeed sticking, and what it looks like to be a notary and otherwise to have documents notarized is changing quite a bit in the context of the post-pandemic world we're all in. So Mara, the updates that you're about to provide, I know are most welcome, so please go ahead. Thank you.
Thanks, Gabe. Good afternoon, everyone. So as Gabe mentioned, there have been several changes, in fact, to New York's notary laws that came about due to the COVID-19 pandemic, but are sticking around post-pandemic and in fact changing even more. So that includes the interim notary rules and for remote notaries, changes to journaling requirements for notaries, among many others. Now, during the pandemic, the courts obviously had to act out of a necessity to adapt very quickly to changing notary requirements just to keep their caseloads moving. And so that's when remote notarizations were first adopted. But the heightened awareness around those issues really put a spotlight, I would say, more widely on some of New York's onerous notary requirements, some that are a little bit outdated as compared to other states or the federal courts. And in particular, the impact that those rules can have on underrepresented and rural New Yorkers who may not have consistent access to proper technology or reliable internet services, which becomes an access to justice issue, as well as creating a backlog in the courts. So what we've seen in the past couple of years is several new rules that relate to notaries that have been passed or amended one or multiple times in an effort to replace the interim pandemic rules. And I'll say that they've been, simply put, nothing short of confusing for many of us. So I'm just going to focus on one of those today. I could do, in fact, have done full hour-long presentations on all of these changes, but I'm going to focus in, and move to the next slide, please, on the recent amendments to the use of affidavits and affirmations under New York civil procedure rules, which now permit any person in New York, and in fact outside of New York, but to submit an affirmation in lieu of an affidavit in civil court actions. So these new rules, the new amendment to the rule, became effective at the beginning of this year. And in fact, it helps New York join over 20 other states, as I noted, that have already sort of adopted similar rules and requirements. Next slide, please. So just to be clear and to make it sure I'm stopping to explain, an affidavit, just as a reminder, would be a document that is signed and requires that signature to be done in front of a notary, whereas an affirmation requires just the signature as a form of a self-attested oath, and you're attesting that it's true and accurate under penalty of perjury. So this is just a highlight of the old rule that was in place under the civil procedure rules, and it really allowed for this affirmation rather than an affidavit to be used only in two instances. The first was for certain professionals, attorneys, physicians, and other categories of professionals, or under subsection B, it was for the statement of any person who was located outside of the United States. Those were the two categories of individuals who could use an affirmation. And you'll note under subsection B, it actually provided language that should be used. Whereas under subsection A for attorneys, you just had to merely affirm to it and sign the document. Next slide, please. So here's the new rule. You'll notice it's a lot more succinct, and it now just applies essentially what was subsection B, or what applied to individuals outside the United States. That now applies to everyone. That includes individuals in and outside the United States. That also includes people of any profession, and it includes attorneys, physicians, and those other professionals that were previously covered under subsection A of the prior rule. However, it also requires that that magic language used at the bottom is now required for everyone. So as an attorney, I now, whereas before I could have just signed a document, I now have to use some form of this magic language to make sure that my affirmation is compliant with this rule. And you will note where it's highlighted that it has to be substantially similar to this language. So that's been a sort of adaptation across using affirmations with our clients to have things signed, but also within our firm and amongst ourselves to make sure that we're using the correct language. Next slide, please. Here's the key takeaways for this new use of an affirmation. It applies to sworn documents in civil cases in New York State. However, as I noted, the federal courts have allowed for this already, so now it's across the board, those can be used. However, there is a little bit of a lack of clarity that needs to be worked out amongst the New York courts around how this applies and interacts with the other 63 sections of the New York procedural rules that reference the use of affidavits and notarized statements. It's assumed that it will apply across all of those, but there's a few of those rules that are a little sticky in the way they're worded. And so we're just waiting for New York courts to weigh in to clarify. Another couple of areas where it's not entirely clear yet would be in discovery responses. So if you're working in a litigation matter and we send you a document that needs to be signed for discovery purposes, verified pleadings in New York State courts, and also sometimes with subpoena responses where you're signing a business record certification, there is some clarity we're still looking for regarding expanding this to allow for just a signature rather than a notarized signature in those instances. The other thing to note is when in doubt, you may still use an affidavit. So the rule just says that it allows for them. It does not say it requires them. So in any of these instances, an individual can still use an affidavit. So when in doubt, go ahead and sign in front of a notary, and that's still going to be effective. And so as we wait for the courts to weigh in, that's sort of a best practice, especially, and I'll give one note, is that some courts have been reported that the clerks themselves are not totally familiar with how these apply yet, and that there's been some instances where the court clerks have rejected certain documents, which would, of course, risk potentially, a statute of limitation or a deadline issue. So that's why our advice is when in doubt to go ahead and use the affidavit. That's all, Gabe. I will pass it back to you.
Thank you so much, Mara. As you mentioned, this could have been an hour presentation. Thank you for keeping it succinct and focusing on one of the areas that you're encountering. And I expect there'll be more that changes over the coming weeks and months. And so please do come on back to the program to keep this group updated. In the meanwhile, though, let me turn to our final speaker for today's program. And I thank you again, Mara. And that final speaker is Devin Harris, who is with us from the New York City office once more and is addressing ERISA. We've heard from Devin a number of times over the course of the spring and summer about what he's seeing in his practice area and activities at the federal level in particular that are piquing his interest. And we're here to get another update from Devin in that vein. So Devin, thank you so much for coming back on. We're glad to have you with us, and please, let's learn. Looking forward to it.
Hi, Gabe. Thank you. Thanks everybody for joining us this afternoon. So yes, thanks Gabe for kicking it to me. I'm Devin Harris here again to present you all with another edition of What's New in Employee Benefits. And as I often do every time I'm on here, I remind and encourage all of you to feel free to reach out if there's a specific topic you'd like me or any of my colleagues to address in any future presentations concerning employee benefits, health and welfare plans, retirement plans, et cetera, and or executive compensation arrangements. We do that work also. So that said, as it happens, today's discussion, or at least part of today's discussion, is a result of a recent listener request regarding an amendment deadline under Secure Act 2.0. I think for some of you out there, there's a perception that written amendments reflecting certain required Secure 2.0 changes are imminent, and that's not the case. In December of 2023, the IRS issued a notice, notice 2024-2, which was essentially a kind of a grab bag notice from the IRS addressing or clarifying 12 seemingly random sections of Secure Act 2.0, ranging from discussions on the modification of credits for small employer pension plan costs to expanding participant auto enrollment in new plans and various other sundry topics that the IRS thought that they should address. It was kind of a random kind of hodgepodge of topics. But important for today's discussion, however, is Section 2J of that grab bag notice, again, notice 2024-2, which addressed sort of the amendment deadlines for Secure Act and Secure Act 2.0. So as originally passed, Section 501 of Secure Act 2.0 provided generally that a retirement plan or an annuity contract under a 403B plan would be treated as operated in accordance with its terms, provided that each Secure 2.0 Act amendment would be adopted by the last day of the first plan year beginning on or after January 1, 2025, or 12/31/2025, or for collectively bargained plans like multi-employer plans and governmental plans, the last day of the first plan year beginning on or after January 1, 2027, so 12/31/2027 for calendar year plans, or provided the wiggle room under the statute, such later dates as the Secretary may prescribe. Notably, that same section of Secure Act 2.0, Section 501, what it did was it aligned the amendment deadlines of the original Secure Act passed in 2019 with the Secure Act 2.0 amendment deadlines. So as it turns out, the Treasury Secretary in the most recent, in this grab bag notice from late 2023, because of the sheer volume of changes under the OG Secure Act from 2019 and its sequel, Secure Act 2.0, the Treasury Department delayed the required and discretionary amendment deadlines for, again, required or discretionary amendments under both Secure and Secure 2.0. So as a result of this grab bag notice for qualified plans, i.e. plans that are not governmental plans or collectively bargained plans like multi-employer plans, the amendment deadline for Secure and Secure 2.0 amendments is 12/31/26. And this also applies for 403B plans not maintained by public schools. For collectively bargained plans, the deadline for plan amendments under Secure and Secure 2.0 is now December 31, 2028. And for governmental plans, the amendment deadline is now 12/31/2029 generally. And this includes amendments for 403B plans maintained by public schools. There are similar amendment deadlines that are applicable for pre-approved plans like prototype plans and volume submitter plans. So your plan document providers should be able to tell you when your deadlines are for those plan amendments. So kind of what's important for everybody to remember, however, is that although these amendment deadlines have been delayed until 26, 2028, or 2029, depending on the type of plan, compliance with Secure Act and Secure Act 2.0 provisions is not delayed. So what this means is that plans, even though they don't have an amendment requirement as of yet, they still need to operate their plans in accordance with the law as of each statutory or regulatory effective date or applicability date. So kind of as an example, when you all last saw me in late July, as I was reminding you or updating you on the new RMD regs that were published earlier this summer, the effective date of the RMD regulations is actually it's September 17th of this year, but the applicability date for these regulations don't apply until 2025. So as I noted earlier, importantly, the amendments for these RMD changes for qualified plans that aren't governmental plans or collectively bargained plans, the amendment deadlines for these RMD changes don't really need to be completed until 12/31/2026. So what this means is that plan sponsors are going to have to comply with the RMD rules regardless of whether they have a written plan amendment in place. And this can be kind of annoying because for a lot of plan sponsors, administrators, and plan practitioners and service providers, having a plan amendment in place is helpful to ensuring proper plan operation. You've got a written plan amendment that administrators and HR departments can turn to. Oftentimes, when there's a plan amendment, there's usually a corresponding amendment to the summary plan description or a summary material modification that's tacked on to the summary plan description. So having kind of like there's a benefit to having the written word to guide plan sponsors, administrators, and service providers to operate the plan documents. So nevertheless, even though deadlines, plan amendment deadlines aren't at least until 2026, I would encourage plan sponsors and administrators to work with their plan document providers and ask if they happen to have any amendments, conforming amendments in place now that they can use that would apply for a particular Secure Act or Secure Act 2.0 change. Or otherwise just check with your plan administrators to confirm and get that peace of mind that, okay, we don't have a plan amendment in place now, but hey, TPA, you're aware that we need to be compliant with the terms of the statute or regulations or other guidance as it comes out to ensure that we're operationally compliant, even though we don't yet have to be documentarily compliant. So to make things even more complicated, although the IRS earlier this year indicated that Secure Act 2.0 would be kind of flooding the zone with their regulatory updates and sub-regulatory updates, so far, it's been more of a trickle than a constant stream or a flood of guidance. So in other words, not much has come out from the IRS since the grab bag notice issued in 2023 came out. And frustratingly, without promised guidance, practitioners, sponsors, and administrators have to kind of do their best to operate their plans using a reasonable good faith interpretation of the statutes until clarifying guidance is issued. So, I mean, that said, I think, quite frankly, the IRS is aware of some of the frustration out there, and they've signaled that more guidance will be forthcoming in the second half of this year. I think a good sort of omen for that is that just yesterday, as I was getting ready for today's presentation, kind of threw a monkey fly in my ointment, I suppose, for today. The IRS issued a new notice 2024-63, concerning a discretionary change that plans can adopt regarding employer matches on student loan payments. So I think a lot of you might be aware that student loans are kind of a crisis for people my age and younger, millennials and Gen Zs. And what it does is the new guidance kind of clarifies and implements Section 110 of the Secure Act, which, as I said, allows employers to provide matching contributions for employees who make plan loan repayments on qualified student loans. So I know I'm running out of time here. So just kind of real quickly, I'm going to run through very generally what the new guidance covers. So it provides general student loan matching contribution eligibility rule guidance, including what the dollar limitations and timing limitations would be. So generally, in order for a qualified student loan to be eligible for a match, the loan repayment, as indicated in the guidance from yesterday, needs to be a loan repayment made by an employee during a plan year for the repayment of a qualified loan or educational expense incurred by the employee to pay for higher education expenses of either the employee's spouse, or the employee's dependent. The loan that's being repaid can't exceed, or the amount of the loan that's being matched can't exceed the generally 402G dollar limit for the plan year. So, for example, the 402G dollar limit for this year, 2024, is $23,000. So the loan repayment couldn't exceed that amount to be matched on. And the loan repayment would have to be certified for the plan year by the employee. Another item that was clarified in yesterday's guidance is, okay, well, there has to be a certification. What does the certification requirement entail? Again, very quickly, in order to be eligible for match, the employee would have to certify that the loan repayments were in fact made during the plan year. And the certification requirement can be satisfied either for each student loan repayment or annually via sort of like a bulk certification regarding each payment throughout the year. Also, the certification would have to include a statement regarding the amount of the loan repayment, the date of the loan repayment, that the loan repayment was in fact made by the employee, and that the loan being repaid was for a qualified higher education expense of the employee's spouse, or the employee's dependent. And finally, the fact that the certification have to show that the loan was incurred by the employee. Yesterday's guidance also, again, kind of gave some squishy advice on if you're going to be matching student loan repayments. It would allow plans to adopt reasonable matching contribution procedures. So again, it was kind of squishy guidance. It's not clear quite yet, but the new guidance says that a plan can establish any reasonable administrative procedures that would implement a qualified student loan payment match feature. And whether the procedures are reasonable would be based on relevant facts and circumstances. And among those would be whether the procedures promote compliance with the qualified student loan match requirements. Yesterday's guidance also covered non-discrimination testing relief for 401k plans that include student loan matching contributions. And kind of notably, as I indicated earlier, sort of the difference between applicability dates and effective dates. This new feature is effective actually in 2024, but yesterday's guidance is not applicable until next year. But for this year, again, as I noted earlier, plan sponsors are encouraged, if they're going to be implementing this match this year, they can rely on good faith, reasonable interpretation of this of the statutory language in section in Secure Act 2.0. And the IRS noted or emphasized that yesterday's guidance serves as an example of good faith, reasonable interpretation of the Secure Act. So if you're going to be implementing it this year, you don't actually have to comply with the notice from last year. I'm sorry, from yesterday. But however, yesterday's guidance in the IRS's mind is an example of a reasonable interpretation. So for all intents and purposes, if you're going to be implementing it this year, it's probably best to refer to yesterday's guidance. So as with everything benefits related that's governed by ERISA or the code, oftentimes these things are clear as mud, but hopefully today's discussion made things a little bit clearer. And as usual, if anybody on today's call has any questions, feel free to reach out to me or any of my colleagues over at Bond and our employee benefits department. And that's pretty much it. So kind of watch the space for more updates. I'm happy to be part of the conversation. I thank Gabe and the firm for letting me chat with everybody today. So yeah, that's it. I'm going to throw it over to our MC, Gabe, for the rest of the presentation. Thanks, everybody.
Thank you, Devin. Really appreciate the updates, especially the hot off the presses material that came out just yesterday. And please come on back to provide more timely updates. If so, if you'd advance to the next slide, please, and the one after that, I will just make sure that everybody is familiar with how to get in touch with today's presenters. Email addresses are listed there. We also just want to remind all of you that sexual harassment prevention training is available through the firm. There are New York State requirements as well as New York City requirements that employers need to heed in this space. And we have products and attorneys who are familiar with how to comply, or the products, I should say, that will help you comply, better put. So just reach out to me or to really any of the attorneys with whom you regularly work, and we'll get you connected with the right resource. And then don't forget the New York Employment Law Guide is also available through the links that you see on the slide here. We are a bit over time, so I'm going to just quickly let you know that I will not be hosting again until September. You'll be with Kristen Smith on the 27th of August, as well the 3rd, right after Labor Day, when we flip into September. I'll be back with you on September 10th. Just a little bit of end of summer juggling in terms of the program, but please trust we will have content for you each of the Tuesdays that follow all the way through the end of the year and thereafter. So we thank you for your loyalty to the program. We know many of you tune in week after week. And we are just thankful for that. And please do reach out directly if you have recommendations on ways we can make the program even more meaningful to you. In the meanwhile, enjoy the rest of your month of August, and I will be with you in September.